unfortunately, there's no one that's going to be appointed to them. Okay, a lot of times you'll have people come to you and say, oh, I'm here to get an attorney. From where? Oh, I thought the court appoints me an attorney, like a public defender. Nope, sorry. It's not your constitutional right to have an attorney to represent you in a divorce, right? It's your constitutional right to have an attorney in a criminal proceeding, absolutely, right? We're talking about due process here. But in a divorce, sorry, you're on your own, okay?
Yeah, so exactly, right? So all these forms, this FL 150, 160, the 140, the last 2 years' taxes, they can be served personally or by mail by yourself. So let's say I'm trying to divorce him. I already had him served. I had him served by a third party with that petition and with that summons, right? And that proof of service looks good. My best friend did it. He signed off. He served him at Starbucks, 123 Main Street in Hayward, 953-94544, whatever. He served him on September 22nd at 3 p.m. Signed date. Great. He was served. This person, my spouse, now knows that there is a case against him.
Hey Eric, it says disclosures due within 60 days. What if it's been like 3 months and I haven't done my disclosures? Is that okay?
I mean, I wouldn't say it's okay, but you want to get them in as soon as possible, right?
So yeah, you do want to get it done as soon as possible. Is the judge going to punish you for doing that? Not necessarily. Okay. The reason people kind of start panicking because it's been, they hear that 60-day limit and they're like, oh my God, it's been like 6 months, I haven't even done this. Chances are they're not going to do much about it, right? The most that the court would do, provided that the respondent hasn't done anything, the most that the court's going to do is going to set a status conference so that you could come into court and the judge would tell you what you need to do. And even with that, they're not necessarily going to tell you what you need to do. They're just going to say, oh, you're going to go to self-help and so that they can tell you about your next steps, right? And then that's what happens all the time is they will come to us directly from that status conference saying, the judge told me to come down here because I don't know what I'm doing, right? That happens almost every day, right? So it's not until either you get that notice from the court or even an order from the court, or maybe the respondent actually appears and they do their disclosures, but you still haven't done yours. That's when you're looking at, okay, maybe I might get in a little bit of trouble, right? Because if you keep delaying it, they could potentially ask the judge to sanction you, right? And have you get kind of punished because you're just kind of frustrating the process, even though you're the one who opened up the case, but you're not doing anything to kind of move it forward. Okay, the other thing a judge might do is see if the other party did their, they appeared into the case, and when I say appeared, they've maybe they're the petitioner and filed the petition, or they actually filed a response, and they've done their disclosures. If you haven't done yours, as a judge, I've got the authority to strike your filings as if you never even appeared, right? And so now I'm going to allow this spouse to proceed with a default because you're just lagging. And I'm sorry, but you had your chance, and you're not taking care of business.
That is a good point to note, is that if someone does end up responding into the case, right, you're going to get people who are the respondents, and you're going to be helping people who are the respondents. They have to do just as much paperwork as the petitioner. They still have to do all this. It's like, I agree with my spouse, that's fine, I'll sign off on it. Okay, but if you responded into it, you also have to complete your forms. You have to do your own duties also in terms of the disclosures and the response. Because when the judge is going to be looking at both of you have done your paperwork, you both have to be ready because then they're going to be making possibly a judgment based on the things that you guys have input, right? And again, so you take it all, so like I was saying about the whole process, right? So Joe already knows that there's a court case against him. This FL 141 is that proof of service for the disclosures. So that's basically saying, like, I had given him this paperwork personally because we still live together because it's so expensive in the Bay Area. I gave it to him personally on, September 22nd, and I gave it to him personally, signed it, and I filed that. The reason that that's okay is because he already knows that there's a case. He doesn't have to be served. There's no court date pending. If I wanted to modify something like a child support, or if I wanted him to give me back some property, or I'm trying to get spousal support immediately, if I'm trying to get him into court, yeah, I gotta reserve him again. If that order was not initially served with the initial petition.
Gary, what if I can't give it to him in person? Can I mail my disclosures to that person?
Absolutely, so
What if I
yeah.
don't know their address?
What's their last known address?
It's 123 Main Street, Hayward, 94544.
That's the last, the best of your own knowledge, that is the best known address that you have for this
Yeah.
individual? Go ahead and send it there.
Okay. So that's what happens all the time, right? People will say, oh, I don't know where this person is. And if they're saying that and they're at the disclosures part already, they've probably not spoken to us. Okay, because if they don't know where this person is, how do they get them served? Right? Sometimes maybe they got them served and then that other person disappeared. At that point I'm like, okay, well, what was the last known mailing address? Oh, I know, it's 123 Main Street. Okay, then you'll mail it there. That's the last known mailing address that you have. You fulfilled your requirement of doing your preliminary disclosure. Okay?
Yeah, and then, again, yeah, so, I mean, it doesn't necessarily have to match where they were served initially, because if someone was served at a Starbucks, or if someone was served at their friend's house at a party, you know, that's not necessarily going to reflect what the, when you personally or mail them their disclosures, because they don't live there, right? But the last known mailing address, you were obviously married to this person, there's going to be some sort of connection. You know, not saying, there are some instances where they're like, we got married and we were together for a week and then I never saw him again. I've seen that, I've seen it. But you also have to put in your best effort to try and either A, find the person, or B, just, you know, this is for the disclosures part, mail it to their last known address for the best of your ability, right? And again, so that's kind of going into the whole judgment phase, because now that you've done your stuff. And the next steps are really going to depend on whether the other party has filed a response or hasn't appeared whatsoever. You know, they haven't appeared to a hearing, they haven't appeared, you did, along with the summons and petition, you also did a request for order for child custody, right?
Ms. Rainey?
Yeah, sorry, I have another question.
Oh, I'm sorry.
Don't apologize.
So I know that if you can potentially do a posting for
Uh-huh.
service. I know it's a process. If you do that for the petition and the summons, and you get your disclosures, do you have to like send anything? Do you have to post anything with the disclosures?
That's a
Or just send
fantastic
them on?
question. The answer is no. You still have to file it.
Right.
But on the form, it's going to be filled out in a very specific way. And if they have a posting, I'm hoping that they're coming to us.
Right.
Because the requirement is, Family Code 2110 says that if there was service by publication, and by publication, does anyone know what I mean when I say service by publication versus service by posting? Let's touch on that a little bit, okay? Let's say you got a fee waiver, right? You couldn't afford to pay your fees, and the fee waiver was actually granted, right? Saying so that you don't have to pay those court filing fees. Well, guess what? If you absolutely cannot find this person, right? And you've tried your best. You've talked to his sister. You went to his last known job, you know, place of employment. You looked him up on Facebook. You looked him up on LinkedIn. You went to the county recorder's office to see if this person owned any property. You went to the county sheriff's inmate locator to see if maybe they were incarcerated. You looked through the California State Department of Corrections to see if maybe they were incarcerated in one of those facilities. You hired a private investigator to see how can I locate this person. If you've done all of these things and the judge is convinced that you've absolutely tried and you just can't find this person, they might allow you to post the petition and summons up on the up on the wall down in room 108. Okay, room 108 is the civil clerk's office down the hallway. All right, so if you have that permission, you're going to have a friend literally pin that stuff up on the wall. And it stays up there for 28 days, and that affects service for the purpose of that service by posting. If you didn't qualify for a fee waiver, you're doing an application for publication, where very similarly, you're doing all these things to try to locate this person, and you still couldn't find them, but now you're asking to have these papers, well really the summons, published in a newspaper, right? Typically it's going to be a newspaper in this county, and you're going to be publishing it, again, for 28 days. At that point, maybe there's effective service that way. Yes, Karina?
It's kind of off topic, but for name change, if they get a fee waiver, can they do posting instead of publication?
For.
For name change, just, you have to have it in the publication for 4 weeks. If they qualify for a fee waiver, can they do posting instead of publication?
There's a separate declaration that we'll do. It's called your declaration of due diligence. It's kind of similar, but it's not quite the same thing. But you're still listing out all the steps that you've done to try to find this person and at least notify them about the name change. But yeah, if they're doing a name change, maybe they might be doing something in the family law case rather than just doing a civil name change. Yeah, but there is a separate declaration for that. Yes.
Yeah, so if you put the posting up on the wall, the idea is that like someone from the general public is in the court.
It's, posting, I know, it's kind of this archaic system of like, oh, back in the day, there might be this public space where all of these bulletins are going to be put up on the wall so that if I had to know about any cases against me, because I wanted to see if someone's suing me, I'd go to that office and check the wall, right? So the presumption is that by doing this posting, maybe this is the best possible place for that respondent to go and figure out, hey, maybe there's a case going on against me. And maybe I'm going to go in there and show and take a look. Oh my God, there's this dissolution of marriage. I'm about to get defaulted, maybe. They're probably not going to use the word defaulted, but I'm getting sued. I mean, if you guys look at the summons, it literally says you are being sued, right? Most people, when they see that, they kind of freak out, right? It's like, what am I doing now that I'm being sued? What am I even being sued for, right? Yeah, or you have been sued. Sorry. And it's important when they get that, because on the back side of the summons, it puts these things called automatic temporary restraining orders. We call them ATROs, right? And these are restraining orders not in the sense of, oh, you can't come in within 100 yards from me, or you need to move away. These are restraining orders pertaining to children. These are restraining orders pertaining to your assets or your insurance, right? So if you're going through this process, guess what? You're not all of a sudden closing up that joint account. You're not all of a sudden going to be moving large sums of money. You're not going to all of a sudden just take your spouse off your health insurance or your car insurance. No big changes, right? Let's say you've got normal expenses that you have to pay for, like your housing or your food or utilities. That's fine, right? If you're using money for your basic necessities, that's acceptable. What's not acceptable is if you're maybe trying to hide the ball, right? And maybe you're doing that by moving some sums of money to a different account. Yes?
So in terms of serving, so I went to serve the person, right? I went through the postings and all that. I cannot locate this person. However, I heard from a cousin of his that he moved back to Brazil, and I have no way to contact this, contact him.
You'd be on that declaration. You'd be saying, maybe I spoke to that cousin. The last I heard was that he was in Brazil. I don't even know where in Brazil. Is it Rio de Janeiro? Is it Bahia? I don't know.
Potential hate issues.
Yeah, and that's a good point. The other thing to keep in mind is Hague Service, the Hague Service Convention. Okay, that's this fancy treaty that a bunch of countries internationally have decided to sign and say, okay, well, if you're going to serve someone in this country, you've got to take some extra steps, right? You've got to go to the consulate and maybe get these papers translated in the official language of that country. Then you got to register it with the consulate. Then you got to go to the judge and ask for something called letters rogatory. Get that translated, go back to the consulate, and then actually have someone go in that country, fill out the proof of service, get that translated. Guess what? This is costing like $4,000 or $5,000, right? Most people in our clinic can't afford that, right? So when they're doing Hague, or when they have a Hague issue, just bring it up with us, right? Because we've got to take a look at if that country is even a signatory to the Hague. If they're not, like, for example, I think the Philippines, they're not a signatory, so you could still get a status-only divorce if the person is personally served over in the Philippines. But guess what? The judge isn't going to make any kind of orders about property or support, because, quite frankly, they don't have the power to make any orders over this person who's over in the Philippines, right? But that's kind of a limited situation. If there is a hate country, or you think that it might be a hate country, like, for example, Mexico, hate country, right? Canada, hate country.
Australia,
Australia,
just because I worked with someone and they do that.
yeah, if that comes up, or if you're just unsure, let the staff know, all right? We can look it up relatively quickly to see whether or not that's appropriate. I actually had to get, I had a bit of a disagreement with a judge a few months ago where she was saying, Taiwan is part of China, but this person was served in Taiwan, so she has to go through hate service. I'm sorry, Joe. I said, Your Honor, I looked it up. Taiwan is, they're not a signatory. I understand that you're considering it to be part of China, but it's very clear on the travel.state.gov website that they're number one, not a signatory, and they're not held to that same kind of standard. So it was fine because it was actually handed to this person. He even signed for it. I have the receipt showing that this litigant signed for it, right? She said, sorry, Joe, I can't do it. 2 days later, she emails me, Joe, you're right. And I'm like, it's fantastic because that judge had the wherewithal to actually look into it herself and see if I was just full of it or not. And she did the right thing, right? But that doesn't always happen, right? And we have the benefit of having such close proximity to these judges, where if I have a question about a judgment or I have a question about an order, I can go to their chambers, right? Maybe not just any time, but I might pop in and say, Your Honor, I've got a question for you about this. And the fantastic thing is, they will talk to us, right? So, and I know we're kind of going off on tangents, but when I go to court, I'm gonna be bringing a few of you with me. I want all of you guys to have an opportunity to go into court, meet some of the judges, see how it happens when you're actually going through these hearings. In most cases, it's going to be dealing with custody and visitation or child support, okay, or even spousal support. And I'm talking about the family law issues, right? I think you're all going to have an opportunity to go to the family law courts, small claims, and what's that?
The DVRO.
DVRO, which, yeah, that's also going to be part of the family law stuff. And the other one is unlawful detainers, right? Folks who are getting evicted, you're a tenant, now your landlord wants to evict you. Have you guys ever been on the second floor when there are hearings for UDs? Ooh, you're in for a treat. Did you guys ever watch like Jerry Springer, that old talk show? I'm not kidding, it's like that. People get violent. People throw things at each other. People have attacked each other in court. People have got slammed on tables. My boss, Amy, have you guys met Amy? She used to practice up there. People would spit at her in court. Okay, it's crazy up there. You're gonna get to see it. It's not always like that. Yeah, no, it's not. No. I'm not saying that to shock the conscience or anything like that. But this is, we're talking about obviously some pretty serious stuff, right? People are getting thrown out of their homes, or people are being separated from their children. There's a lot at stake, right? Maybe not a lot of money's at stake, but how much value can you really put on the amount of time you spend with your son or daughter or your children? That's priceless, right? So of course people are fueled up. People are really charged up. Of course I'm pretty upset because I'm getting evicted and I'm a 93-year-old man and I have terminal cancer and now this person's trying to evict me. I can't even stay awake, right? We had a customer, and Eric was helping, where this guy literally couldn't stay awake because he was frail. He was like, what, 91?
He was, 91, and he fell. He was sitting down waiting to be called into our office, and he fell because he was sitting down and so frail, we had to help him inside. He was being evicted, and not only that, but we recently learned that the checks that he was going to use for his payments were potentially being stolen by a roommate because he was just so lonely. He didn't have a roommate, but he just had someone, he had a friend that he met on the bus, and he just started keeping him company. We have these elderly people who are very, want to give, and they just want company because they don't have any other family or friends. So yeah, he'll meet someone on the bus, and they'll take advantage of him, and soon that will eventually ruin him because of his good gesture. And he had the sheriff's notice, he had a day left, and potentially been thrown out. I have to follow up with that case again, but You know, it's just those things that you see this man crying and he says, don't even bother to help me, just put a 38 in my head. You know, it's things like that. People are absolutely emotional, and you gotta, you know, you gotta be strong there for them. So they say, you know, everyone wants to attend criminal trials, but if those people are in handcuffs, you have these civil where it's all emotions, right? It's all emotions, logic goes out the window because they see their child right there, and they may, you know, there may be supervised visitations from now on, or they may be notes.
Yeah, why should I be supervised? Why do I need a professional supervisor? I've been raising this kid my entire life, right? Why do I need someone to watch me while I'm just literally playing chess?
Because you have a drinking problem.
Yeah, maybe I've got a drinking problem. Maybe I've got anger management problems. Maybe this child, unfortunately, has seen me beat my spouse up, right? And maybe this child needs to be in a safe setting, and that's why I'm ordering supervised visits, until you can prove to me that you don't have to do that, right? So yeah, like I said, I don't take this stuff lightly. I used to practice, you know, for about 6.5 years before I came here. So I've seen all kinds of stuff. And I'm continuing to see all kinds of stuff over here. But let's move on to the last step. I know we kind of skipped around a bit. Yes, Ms. Rainey.
I don't think we answered the question about delivery of financial disclosures if you did a posting.
Oh, I'm so sorry. Yeah.
2110.
So on the FL 141, it would be saying that the petitioner's preliminary disclosures were delivered, and we would check the box for other, and we would just say no service necessary per Family Code 2110.
Okay.
Yeah, but, yeah, and I'm sorry for
No, it's
digressing.
okay.
But yeah, so the disclosures still have to be filed, okay? But it doesn't necessarily have to be served, right? Because the logic behind that is, well, I did the service by publication or posting anyway, right? If you absolutely wanted to just mail it to the last known mailing address, you could, right? But 2110 doesn't even require that.
So after we go over this brief overview, you guys, I will show you how to fill out the initial forms of starting, and show you guys what a proof of service is, et cetera, because you guys are going to have to start looking for these things when you're helping someone.
So I'm going to step 3.
Yeah, we're on to step 3 now. All right, I've done my disclosures. I've given them to Joe. I've given him my FL 150 separate, my community property. I gave him my last 2 years' taxes. I'm ready for my final step. So there's a couple things you got to look at, Joe.
So I'll go into that, okay? The reason we break it down into 1, 2, 3 is it kind of simplifies it for folks, right? It kind of gives them a sense that, okay, obviously there are things that I have to go through, there are a few hoops that I have to jump through in order to get my divorce, right? So before they can even get to step 2, we've got to see that step 1 has happened, right? And that means that, yeah, there is a petition, a summons, and a UCCJEA if there's a kid, and on top of that, there's a valid proof of service, right? That's where a lot of people get hung up, is that proof of service is either wrong or there's something that's deficient about it. Like, for example, it'll say that, yeah, the petition and summons was served on the respondent, but it doesn't say where it happened, right? Or maybe it does say where it happened, it has the address, but it doesn't say when, it doesn't say the date or the time. Or maybe it has all of that stuff, but the person who filled it out, or the person who did that service, didn't bother to write their name down. They just signed it on the back, thinking that was enough. It's gonna be tough, right? Because I'm not even gonna move on to step 2 until I see that valid proof of service, right? And even if I do see that valid proof of service, I still look at their initial petition and summons, right? Because if there's something wrong with their petition and summons, and Eric's gonna get into that when we're going over the form, but if there's something wrong with that, I'm gonna tell them, look, there's something wrong with your petition. Oh, but I filed it with the clerk, it should be fine. And you know what? The clerk doesn't do what we do, right? The clerks, their job is to file those things for these folks. It's not their job to tell them you messed up on this form. It's not their job to say you're supposed to check this box, right? And a lot of times they think that just because they filed it, that it's been checked. Not true, right? And the clerks, in their defense, it should not be held against them for not doing that, right? Because that's not their job. Why are you going to have them accountable for something that's not even their responsibility? And so I always tell my customers, don't hold that against them, right? If you wanted the help and you wanted to do it the right way, you come to me. You come to any one of us at Self-Help, right? We will help you out. We'll tell you if you messed up. And if you did mess up, I'm going to suggest that you do an amended petition, right, so that we can correct it. One of the most common ones that I see is the lack of an actual data separation, right? They'll say, okay, date of marriage, no doubt. It was April 1st, 2014. Data separation, August 2017. That doesn't help me, right? That doesn't help the court, right? Because remember, we're trying to establish that cutoff point. And if they say August 2017, I will tell them, look, can you get this served again? You know, can we amend this and get this served on the respondent one more time? That's going to be difficult. That's not the question. Can it be served? Yeah, right? And if they're saying no, then I'll tell them, look, you run the risk of your judgment being held up, right? Because you didn't provide that information about the data separation, right? I've seen it where they they go through step 1, step 2, and they're still missing that information. I've seen it be okay with some judges where at the very end they do a separate declaration saying, you know what, at the time that I filed my petition, maybe I was a bonehead and I just neglected to write that it was August 1st. Yes, Preston?
I have a question. So let's say a litigant comes in and I notice that something needs to be amended and they have to reserve. Do they have to wait the 30 days?
If you're amending the summons,
The summons?
yes.
Yes, okay.
Yeah.
But not the petition?
Not the petition.
Okay.
No. They still do have, another 30 days to respond.
Uh-huh.
But in terms of, sorry, hold on. Was it going to be?
Yeah, it's connected to that.
Okay.
But so then you have to reserve, right? If you're reserving the summons, does the clock start over again?
Yeah.
You have to reserve summons, but not if you're reserving the petition.
Just an amended petition? No.
The amendment.
Okay.
Yeah. The summons is what starts that. Actually, no, I'm sorry. Strike that.
Okay.
No, it does start the clock over 30 days. The summons, what that restarts is the jurisdiction date. I'm sorry. That's my
Okay.
response, my fault. Do you guys understand what I mean by that? Right? Let's say you got them served with that initial petition and summons that was all messed up, and it was served on a certain day, right? That's the day that the court actually has jurisdiction over that person, right? Provided that they were served here in California, right? Or maybe they were served by mail. So if you are amending that petition and or summons and getting that reserved, yeah, it does start that 30 days again. I'm sorry. But if you're amending the summons and they're getting served with that summons as well, that starts a new jurisdiction date, right? Because on the summons, sometimes people will write their name, put the court address, but not put an address, right? Not put their own address. Or maybe they will put just their name, respondent's name, and just the court information, and that's it. And somehow they got it filed, right? That summons needs to be fixed. And like I said, if that summons gets amended and gets reserved, that starts a new jurisdiction date, okay? Whereas if they were amending that petition, yes, they do wait that 30 days again, but it doesn't give a new jurisdiction date. It could still be that original date back in April. Thank you, that's good clarification. Yes?
Just in case you were going to sit back.
Oh, thanks. And yeah, with step 2, right, I've got to see that, at the very least, I see the 150, the income and expense declaration, I see both 160s, and I see that 141 file, showing that the disclosures have happened. If that hasn't happened, I'm not even moving on to step 3, okay? And I'll be very clear with them about that. Look, you haven't done it. Oh, but I filled it out, I sent it. Yeah, but you didn't file it, right? And I can't go to step 3 and prepare a judgment for you without seeing what you're even declaring, right? Because inevitably, they're gonna come back to me and say, I want help with the judgment, right? I just want to be divorced now. Well, if you didn't file those documents saying what's your asset or what's your debt, how am I gonna prepare a judgment for you, right? Because I can't confirm anything if you haven't filed it. And I have nothing to show for it, right? If they have it, okay, let's get it filed. Let's get it filed right now, right? Then maybe we're moving on to step 3. And so you'll see with step 3, there's kind of 3 options, right? A default judgment is going to be, you did service, or not you, someone else over the age of 18, not a party to the action, served the other party with that petition and summons, and they never responded within 30 days. You can do a default judgment, right? A default judgment is gonna be incorporating everything that you asked for in that petition, everything that you've disclosed in that, in those disclosures, and you're doing it without the court, or without the respondent having any kind of input, right? And a lot of times that happens because I know that we're gonna have an agreement, right? And I know that my spouse is just gonna take care of it, and it's fine, I'm seeing everything, they're not trying to pull something over me, it's cool, right? At that point, it might just be a pure default with no signature from the respondent. A lot of times you'll have people say, no, you know what? They're not gonna respond because they don't wanna pay that filing fee, or they don't wanna go through all the other exercises of filling out these papers like you had to do as a petitioner. And so, at the end, ultimately, that respondent just wants to sign off on the agreement because this is what we want, right? This is what we think is best for our kid, and this is what we think is best for us in terms of what we're doing about our money or our debts. And so they'll do a default judgment, but it's a default with an agreement, right? And at that point, both of them would need to get that notarized because you're representing yourselves, right? Whenever you're representing yourselves, the judgment has to be notarized, okay? And that's obviously to protect the parties, right? Why are you just gonna submit something with some signatures without some actual proof that you are who you say you are, right? And with the notary, obviously, they're gonna check your ID, they're gonna take your thumbprint, and then they're gonna put an acknowledgement on that judgment saying that, yeah, this person appeared before me and signed this judgment of dissolution. This respondent appeared in front of me, provided that ID, and signed this in front of me. Yes, ma'am?
So we agree on everything, he will let me divorce, you know, we agree,
Mhm.
but he just wants to make sure that I'm gonna give him his additional rights to our daughter. Will he have to respond at some point?
No, he doesn't have to, right? Because if that agreement includes what, you know, or that judgment includes what the plan is, right? Then you write it up and you both sign off on it,
Okay.
right? Because the way we do it when we have the petition, you're gonna see, and Eric will show you, is that there are certain boxes that are gonna be marked, right? So there's two parts of custody, physical custody and legal custody. Do you guys know the difference? I know a few of you do. Anyone? No? Yes.
Legal custody is who makes the decision for the child, so the school will be figure everyone's adopted to see the physical custody, like who they stay with, most of that.
You've been listening, yeah. Right? So that's exactly what it is, right? So two parts. And a lot of times they're gonna say, oh, I want both, right? So maybe you're gonna be marking those boxes for the petitioner. Maybe the two of you say, yeah, you know, we're gonna co-parent. We wanna do this together. Even though we're not together anymore, we still wanna raise this child the right way. Maybe we're gonna do it jointly, right? Or, not that often, but a lot of times, or not a lot of times, we'll have someone say, you know what, I'm okay with my child living with, you know, his mother. I'm okay with her making all the decisions. I just want visitation time, right? I just want to be able to see my kid, right? So we'll mark a certain box on that petition. But yeah, so that's kind of where I was going with the default, because if you mark that custody box a certain way, we're going to mimic exactly how you did it in that petition, right? Because we're assuming that you haven't maybe filed any motions to get into court to actually get a specific plan from the judge, right? Sometimes people will file a motion and say, look, I want to make sure that dad has every Friday to Sunday, right? Or I want to make sure that we have a 50-50 split where it's week on, week off, because we still live in the same city. It just makes sense, right? We can work this out. And if you actually have an order, then that gets incorporated as part of your judgment too, okay? With child support, you're gonna hear this a lot too. People will say, no, we don't wanna do anything about child support, we're good. You know, we both have determined that when the child is in my care, I'm gonna take care of whatever expenses need to be paid. When it's in her care, she's gonna pay for any of those expenses. And any daycare, we just know we're gonna split, right? Or any out-of-pocket medical expenses, we know we're gonna split. Oh, my child needs braces, it's $6,000, guess what? I'm out of pocket $3,000 because that's what's fair, right? Both of us have a responsibility to this child, so we're gonna both equally share those expenses. And if that's the case, then fine, right? You don't have to file a motion to ask for the child support. And when you get to the part of where you're doing your judgment, if you have that agreement where you're saying, look, neither of us are gonna pay each other anything, right? What you'd be doing is in the judgment, you'd just be reserving on that issue of child support. And reserving is essentially setting it at 0, right? But just maintaining that someone at least is going to maintain some health insurance for the kid. Someone at least is going to be responsible for daycare expenses, and by someone I mean both of you, because it's going to be 50-50. And then out-of-pocket medical expenses, right? But as to the base child support amount, it's going to be 0, right? If either one of you are receiving cash aid, welfare, then it needs to be signed off by the Department of Child Support Services before it even gets to the judge. Yes, Shai?
I know you say you put like the amount at 0, but would you have to say like in writing that you're like splitting everything, like all the expenses?
It's up to you, right? It's up to you what your agreement actually is, right? Because if you're just filling out the petition, you'll see on the child support section, you're not marking anything. There's a box that says other, and to be quite honest, I don't know why that box is even there because it's kind of unnecessary. Maybe the Judicial Council has an explanation for it, I just don't know it. But a lot of times people will try to mark that box and say, oh, no child support. We agreed that no one's going to pay anything. That's their choice if they want to put that. I typically discourage people from writing that in just because the default anyway is that reservation where it's still at that 0 amount, right? So yeah, that's where we're kind of at for the default. Like I said, they didn't respond, but the petitioner took care of 1 and 2. Now they're at 3, and either they're doing it with an agreement or without. Yes, Mr. Amy?
So that agreement you're referring to, is that the marriage settlement agreement?
It could be,
Is
yeah.
that done a certain way, like on pleading paper, or is it?
Depends on where you go, right? Sometimes people will go to an attorney or a document preparer or paralegal and get it written up on pleading paper. With certain, a lot of times the typical MSA is going to have a recitation of the facts, right? The parties were married on a certain day. They separated on this day. They have 2 children of this marriage, date of birth, blah, 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 right? The parties, due to irreconcilable differences, have decided to proceed with dissolution of marriage, and then it lays out the terms. This is what we're going to do about custody and visitation. This is what we're going to do about child support, spousal support, reimbursements.